All right, welcome everybody back to Dan and Brendan here talking about current events and constitutional law issues. And one of the questions that people had on Facebook was about the meat processing plants and President Trump ordering those plants to stay open. And there were questions about whether he could do that. And we want to talk about two things today. Number one is whether under Article 2, that's a valid exercise of his power, but also whether there's any remedy for the people who work at those plants, right? Those are the two things we're going to talk about today. As to the first issue, does Donald Trump have the authority to do that? Dan and I both are, taught many times this case called Youngstown, which was a case where Harry Truman in 1952 tried to seize steel mills because workers there were going on strike, and he said we need the steel to fight the Korean, what they called then the conflict or the police action. And the court said wrong branch. Now, there have been a couple videos now about this. Each branch of government is supposed to stay in its lane, right? The Congress is supposed to make the law, the president is supposed to execute the law, and the courts are supposed to interpret and apply the law. And what the court said in Youngstown is we got the wrong branch here because the president acted without Congress. So how about that? What does it mean to be the chief executive?
Yeah, there are a couple of issues that I think we hope to at least touch upon. One is the Youngstown issue that we're going to talk about. And the second is sort of a due process question that flows from all of this. But in terms of Youngstown, and I know you've touched upon this before in previous videos, so I don't want to rehash a lot of what you've already done. But the long and the short of it is we have three co-equal branches, right? We've got the legislative, the executive, and the judicial branch. The president can't just act on the president's own initiative, at least in some circumstances. The president needs the sort of say-so of Congress, if you will, to legitimize what it is that the president is doing. That's what the court said in Youngstown. The court basically said, and I guess we may not want to get too deep into this, but there are actually a couple of different opinions in Youngstown. The first is Justice Black's majority opinion, where he said, it's a simple inquiry. We ask if the president has the authority under the Constitution. If yes, then it's good to go. If no, then we ask whether Congress gave the president authority to act. If yes, then the president's good to go. If not, then we got a real problem. The controlling opinion, though, the opinion that courts use today is something known as Justice Jackson's concurring opinion. And in his concurring opinion, Justice Jackson laid out three tiers of presidential action. The first is when the president acts with the authority of Congress. Congress specifically says, by way of a law, Mr. President, you may do X. And if the president then acts within the scope of that authority, we've got no constitutional concern. At the other end of the spectrum is the case where Congress says to the president, you may not do X, but the president does it anyway. The president acts outside of any authorization by Congress. In that case, you can see, right, we've got a fairly clear butting of heads, if you will, between two co-equal branches. And that's the category, one of the categories that causes courts lots of problems. Then, of course, there's a middle ground as well, Youngstown Category 2, where Congress has been silent. Congress really hasn't addressed this situation in particular. And so it's up to the courts to decide whether Congress would be okay with what the president has done based upon similar things that Congress may have authorized in the past. So these three categories, Category 1, Congress says go ahead. Category 2, Congress is silent. Category 3, Congress says don't do it, but the president acts anyway. That's the sort of analytical framework that courts use today to decide on constitutional questions involving presidential action.
Right, and the reason Truman lost, right, in the Youngstown case, the court said that he didn't have the authority to seize steel mills, domestic steel mills, Well, first of all, the Constitution didn't authorize him to do that. Second of all, there was no statute to authorize him to do that. And as Justice Jackson said in the concurring opinion, he said Truman's in Zone 3 because not only because Congress is not silent, because Congress has set out mechanisms for how to deal with a situation like this, and they specifically rejected, right, the idea of simple governmental seizure of private property under those circumstances. So Truman was in Zone 3. I guess this, I don't know if people will want to hear this, but what Donald Trump has going for him here is he's probably in Zone 1. One of the things that the court had a problem with in Youngstown was that Truman did not invoke what's called the Defense Production Act, right, to address the problem he was facing. That law was on the books at the time because that's a 1950 statute. And so the court specifically said, if you had just done it that way, then you would have authorization from Congress. So what Donald Trump has done is invoke that very law, the Defense Production Act, which does have mechanisms in it for declaring certain businesses critical infrastructure and ordering them to stay open. So I think we kind of agree on this. We were talking before we recorded that might be a political hot potato or a political question, right, that needs to be addressed. But as far as Article 2 and Youngstown are concerned, Donald Trump's probably on terra firma, so to speak.
Yeah, I agree. I think that it's fairly clear as a constitutional matter that Congress authorized the president to invoke the DPA, the Defense Production Act, for precisely this kind of circumstance. Now, there's room to argue a little bit around the edges, but I don't think in particular this Supreme Court is going to go anywhere near that argument. It's a fairly clear case, I think, of Youngstown Category 1, where the president has acted within the scope of Congress's authorization. So as a constitutional matter, I think Trump is on fairly solid ground. But as you point out, that's not the end of the inquiry here, at least as a political matter, because as I think probably a lot of our viewers know, in response to the president's invocation of the DPA, any number of meatpacking workers basically said, we ain't going.
Mm-hmm.
And so the question then becomes, what do you do if you're the president? You show up in court and try to force these people to go back to work if you're the president. And I think most courts are going to say, hey, that's not a legal question. That's not a constitutional question. That's a political problem, Mr. President. Mm-hmm. Figure that out on your own and leave us out of it.
Right. And incidentally, the DPA, the Defense Production Act of 1950, that authorizes the president to tell Tyson or whomever, you got to keep your plants open. But no, the way I read it, it does not authorize the president to order individual workers back to work. Then that becomes a problem between the company and the employee, right? Of how that's going to be handled. But this is a good segue into our second issue. Okay, so the president had the authority to order the meat processing plants to stay open. We have workers who don't want to go back to work. Now, we talked about there's a political issue there. Is there any, or I should put it this way, what would be the primary legal hurdle from a constitutional standpoint of an employee saying, by forcing me to go back to work, you've deprived me of my health or possibly my life, right, without due process? If you want to take that on for a little bit.
Yeah, let's sort of take this step by step. President invokes DPA and tells meatpacking plants they've got to keep their doors open. Now, at that level, I think there's already a due process issue in play as between the national government and the meatpacking employers themselves, right? Because the meatpackers are now compelled to open their doors and turn the lights on, and as soon as they do that, they immediately incur fixed costs and variable costs as well. So they're going to be out of pocket regardless of whether any workers actually show up and allow them to generate revenue. So there's a due process question as between government and employer. Employer then says to employees, guess what? We've got to open the doors and turn the lights on. You all have to come back to work. Well, as a constitutional matter, the problem there is the meatpackers aren't what we call state actors. The Constitution, as a rule, only applies to state actors. And when you think that, for the most part, it makes sense to think about states and government officials themselves. Well, we don't have that kind of direct order between the federal government and the employees. We've got an order that runs from the federal government to the meat packers. It's the meat packers that are ordering the employees then to return to work. And as a classic matter of constitutional law, technically, and again, there's room to argue this, and I know that there are state action arguments floating around, but technically there's no state action here. So the employees themselves may not have a constitutional claim as against the federal government. That then raises yet another issue that you and I talked about before we went live recording here. And that is, what happens in those states where a governor issues a return to work order or you forfeit state benefits? And I've heard of this happening in at least one instance where the state governor set up an online web reporting site for employers. If employees refuse to return to work, employers can report those employees to the state. State will then consider those to be voluntary separations and will deny unemployment benefits. Then it's clear the employees have a constitutional claim against the state, but not necessarily against the federal government. Does that make sense?
Yep. And I think probably we've just hopefully clarified two topics, one of which I think is widely misunderstood, right? The first is, look, if the Congress, the root of the word executive is execute, right? So the president's job is to execute the law. So if Congress tells the president that you can do something, then the president can do it. But I think the issue that hopefully we've clarified that is really widely misunderstood, and I don't know if this has been your experience, but I think that there's a widespread assumption that a private individual can violate somebody's constitutional rights. And the Constitution, it's a speed limit or a stop sign that's facing the government, right? Not the individual.
That's right.
So if there's a dispute, if it's the meat processor that fires the employee rather than the government that fires the employee, we have a problem. My favorite example of this, and I'll try to be really quick, I don't know why this sticks in my head, but years ago I saw Sarah Palin, who was running for vice president, complaining that a private radio station had cut her off, right, or wouldn't let her fully answer a question. And she says, well, they violated my First Amendment rights. Of course, and every lawyer in America is saying, well, that's pretty ignorant because a private radio station cannot violate somebody's First Amendment rights because it's not the government. So I hope that point sticks because, again, I hear that so often, the assumption that a private employer or a private party of any kind can violate the Constitution. It just can't.
There's some room to argue around the edges there, as we've talked about, right? To what extent is a meatpacking employer a state actor if that meatpacking employer is acting at the direction and behest of the federal government under a federal command that is compulsory, like the DPA? So there's room to argue, but the point remains valid. There is no constitutional violation as a rule without state action. So that's the problem that we face.
I should have been clear about that. That's the general rule, right? Of course, there's always exceptions because what fun is a rule without an exception, right?
Yes.
But yeah, and that leaves us with, I think the next video we're going to do is going to be about a topic that's really very practical and impactful, and that is the issue you just raised about governors taking away people's unemployment benefits because they refuse to go back to work. As you say, there's a clear state action issue there, or I should say state action is clearly present there. So we're going to, I think in our next video, kind of tackle that, as there's kind of due process issue available to those people. All right. I think we just covered a lot of territory and a reasonable amount of space.
We did, yeah.
All right, and if anybody heard a little bit of growling and barking in the background, that's because the star of the show, the dog, who's now peaceful, decided to interrupt us several times. So
she's doing the job, man. Back off.
Right? That's right. Very busy dog.
24/7, man. Let her do her thing.
That's right. All right. Well, I'll see you for the next one. Stay safe up there.
Thanks. See you, everybody.